Someone make it make sense.
Probably a couple.
Hello, everybody. Welcome. We got another Kohberger live stream here. Happy to be back after a long day with Lori Vallow and lack of a verdict. I'm sure we will get updates here from those in the courtroom, especially Nate Eaton shortly, as to what exactly went on. But apparently they only deliberated for like 19 minutes or something, and then they went home. So we will find out, but they will be continuing on tomorrow. Of course, we also have Karen Reed's opening statements and first day of trial, of the retrial anyway, tomorrow as well. So we're just going to clone everybody. Well, me, clone myself so that I can be in multiple places at once. It's all good. But in other news, we do have some new custom emoji because we unlocked that level with having enough members. As you have new members join, YouTube allows you to do more things, including adding more custom emojis. So we do have more custom emoji. Speaking of members, shout out to all of our channel members. And we will be redirecting this live stream into our members only live stream with Trivia Night. So super excited about that. Hopefully we will have some of our new members joining us. A huge shout out to Meg, who gifted like 50 bazillion memberships between yesterday and today and made a lot of people members who are now able to join us for that live stream. So that is exciting as well. So we are just picking up where we left off from last night with these latest court filings, as you can see here. In red, as always, we have these orders coming in on the motions in limine. And so last time we covered the order memorializing the oral rulings and motions in limine. And we also covered the suspect vehicle and the bushy eyebrows identification. So this time we are going to be covering the touch and contact DNA and the neuropsychological and psychiatric evidence. But actually, first, let me grab some water real quick. I forgot to grab that. Give me 1 sec. Gotta stay hydrated, people. Am I right? Shout out to Franks. And shout out to James as well. First like. So speaking of which, we need to also test out the Brennan command has worked once, and then it stopped working again. And we are in the wake of the Karen Reed trial retrial starting again tomorrow. We got to make sure this command is working. Speaking of the new custom emoji, one of them is a red solo cup. Just in time again for this retrial. Oh, Nightbot. Nightbot is so funny. So, I was going to say something else. What was it? Having to do with maybe the custom emoji. Let me just see if I can get this Brennan command to work, though. So, so the good news, though, is that it looks like the jury will be coming back in potentially during the lunch break during Karen Reed. So that might work out okay. What I plan to do is cover Karen Reed in the morning and then probably switch over to Lori Vallow. And then potentially, if we're still on verdict watch, then we might do the afternoon sesh for Karen Reed, like, in the evening or whatever. So that might be how we kind of make that work. But it's so funny with these trials, right? Because sometimes it's just all up in the air and it's hard to know how things are going to go, especially when you're on verdict watch. Although we all seem to think that there is going to be a verdict today. So let me just see if this changes anything for this command for Nightbot. Being finicky, it may or may not. We shall see. All right, so without further ado, though, looks like that didn't make a difference. Oh, Nightbot, you silly head. All right, so we are going to jump right on in here. So we'll start with the DNA. All righty. Make it bigger. Can I make it bigger? Make it bigger. Excelente. All right. So defendant moves in limine. Okay. Exclude the testimony of Riley Nolan to testify about touch DNA and the transfer of DNA, and generally and more specifically that the DNA located on the knife sheath was more likely the result of a direct transfer. Welcome, AZ. Defendant argues that Ms. Nolan's testimony, as well as any other testimony referencing the terms touch or contact DNA and or purporting to be an opinion about the means or mechanism how the DNA ended up on the knife sheath, is irrelevant or impermissible under the Idaho Rules of Evidence. .703, by the way, that's expert witness testimony here. All right, oral argument on the motion was held on April 9th. Okay, so, okay, interesting. All right, okay, so let me read this. Okay, oral argument was heard on the 9th. The court does not find the exclusion of Ms. Nolan's opinions is warranted. However, the court requests that the parties instruct their witnesses to avoid the use of terms touch DNA, contact DNA, and trace DNA. This is a really great ruling and surprising. I don't think he indicated that he was going to be going this route in the hearing. And I remember thinking that it would be, I remember him saying things like, you know, sort of like, what's the saying? Like a rose by any other name, right? You call it such and such thing and as if, and I took that to mean that if they call it touch DNA or contact DNA or trace DNA, it doesn't matter anyway, because they're going to explain it. So I expected this to be denied. So this is a pleasant surprise because I actually think this is a great ruling because it is misleading and it is a huge controversial issue in the field. And actually Franks might even be able to speak to that as well, because Franks is it's going to be this summer, right, Franks, when you're going to be in that program for IGG. But anyway, okay. Welcome, JB. Happy to see you back as well. All right. So standards. The admissibility of expert opinion testimony is discretionary. Okay. Likewise, whether to exclude evidence under the rules is discretionary. On these discretionary matters, the trial court must, one, and I'm not going to read all these. He cited these in each of these rulings. They're all the same. Okay. So here's the facts. A knife sheath was okay, in August, coolio, cool. So wondering what you think about this, not using the words touch or contact or trace DNA. A knife sheath was recovered from the crime scene in this matter and swabbed for DNA. A sample of DNA identified as Q1.1 was extracted from the swab by the Idaho State Police, subsequently tested. The state disclosed Riley Nolan, the lab manager for Idaho State Police, to testify to the operations of a forensic laboratory, the structure of the ISP lab, and the types of evidence it processes. Her disclosure further states. Ms. Nolan will also testify to touch DNA and transfer of DNA. Specifically, Nolan will testify to the characteristics and nature of touch DNA, including how it is deposited and transferred to an item of evidence, the methods used to collect and preserve touch DNA, samples from items of evidence, the procedures and protocols used by forensic scientists to extract and analyze touch DNA, the manner in which results from touch DNA samples are interpreted, and the reliability of touch DNA analysis and its acceptability in the field of forensic science. Nolan will also testify to the potential for DNA to transfer between an individual and an object or objects plural, including the distinction between primary and secondary transfer and the factors including the likelihood of transfer. It kind of backfired. I don't know. I am reading this for the first time right now, so we shall see. So far, I was like glad that they wanted him. They want, like, the defense asked for them not to use those terms, right? Touch DNA, contact, trace. So far, it sounds like it's a ruling in favor of the defense, right? This was their motion in limine. But I'm wondering if maybe you're referencing something I haven't gotten to yet, AZ. Okay, on February 17th, 2025, the state submitted its rebuttal disclosures, including one from Ms. Nolan. The focus of the second disclosure is touch/contact DNA and direct versus indirect transfer, including factors that can influence the transfer and persistence of DNA on an item. Final paragraph of her rebuttal disclosure states, many complicated factors can influence the likelihood of transfer DNA and the persistence of the transferred DNA after deposition. Current DNA technology cannot conclusively answer the question of when DNA was deposited on an item or by what mechanism, i.e. direct or indirect transfer. It is possible the DNA detected on item 1.1 resulted from secondary transfer. However, based on Ms. Nolan's training and experience, it is her opinion, given the quantity of DNA that was detected, that it was obtained from a single source is more likely a result of direct transfer. Analysis. Defendant's argument is threefold. First, he seeks to exclude any testimony by Ms. Nolan regarding when and how the DNA found on the knife sheath was transferred there, arguing it conflicts with the current consensus within the forensic science community, is outside her expertise, and is speculative. Second, he argues generally that the terms touch and contact DNA should be prohibited at trial as misleading, confusing, and unfairly prejudicial. Finally, he argues that Ms. Nolan's rebuttal opinions must be stricken as improper rebuttal. Each will be addressed in turn. So Ms. Nolan may offer disclosed testimony about DNA transfer if scientific, technical, or other specialized knowledge will assist the trier of fact to understand the evidence or determine a fact, an issue, or witness qualified as an expert by knowledge, skill, experience, training, or education may testify thereto in the form of an opinion or otherwise. Citing case law there for expert opinion testimony. We know all this, how this works with expert opinions. So he's saying she's sufficiently qualified. Whether a witness is sufficiently qualified as an expert is a matter largely within the discretion of the trial court. I'm not going to worry about this part too much. He's said she's qualified. I expected that to be the case. So we're going to go ahead to the other issues here regarding the languaging, right? Did he separate that out? Hold on. Okay, well, this is, I guess he's putting this within that same category, but this is what I'm looking for here. So with regard to expert testimony regarding the transfer of DNA, the report explains, okay, he's referencing that report. Let me go back up here, actually. The how and when questions, right? So it further states that providing opinions about the probability or possibility of direct or indirect transfer is problematic, stating, evaluations considering factors such as transfer, persistence, and background require an evaluation of the biological results given propositions that address not the source of the DNA, but the activities that may have taken place. This in turn requires the use of data, knowledge, and expertise on DNA transfer, persistence, prevalence, and recovery, rather than knowledge of the DNA profile. Characteristics, probabilistic genotyping software, and population frequencies. So what they're saying here, this is from, I think, one of the articles cited by the defense, is that how DNA can get on a certain place is a different skill set and area of expertise versus like the DNA profile characteristics, right? Which I would agree. I think that's true. And again, to use the example from Casey Anthony, they had brought in, like they had multiple different experts within the field of DNA because they had one person who specifically was only like, that was their expertise, was like touch and contact and all that transfer versus like looking at a DNA profile type of thing. So Franks is saying, I think they would have been better off from the defense point of view, having it referred to as touch DNA. They could hammer home how little cells are involved. What are they going to call it? Just DNA? Interesting. Yeah. Yeah. I mean, I don't disagree. It's just interesting, right? I think that it's an interesting concept because it's really kind of a gamble, right? Like with calling it touch DNA, I think that the risk that many defense attorneys, potentially see there is that the jury's going to hear touch DNA and maybe tune out the rest of the science because they find it boring or it's just like, sometimes that can be quite dense, right? That they hear touch DNA and they think that means, oh, the person touched the thing, right? Like they touched the thing. But I totally agree, like, because when you really fully understand it, right? A, that's not what it means, but B, it really does diminish potentially the reliability and the weight of that evidence, right? Like, again, like how few cells. And I agree. I think trace DNA is a much better way to put it. I like that. And here's why. Because that does both things. You could use trace DNA. You could use that in a situation where somebody did touch the thing or it did transfer or whatever, but regardless, it doesn't have that same connotation. Trace DNA is I think that's a fair way to put it because that's what it is. It's trace DNA, right? And that is an accurate description. And then as far as the mechanism, that can be testified about. I think if I were a juror and I heard trace DNA, I would like want to learn more, like, oh, it's trace. That would make me want to listen, versus the touch thing. You can see again where some jurors might tune that out because they're like, oh, it means the person touched it. I get it. Right. Enough said. So yeah, I totally agree there. Trace can give the wrong impression too. I mean, I do think, I mean, I think the trace is so far between touch, contact, and I think trace is pretty fair. I think trace is fair. And I don't remember what the defense said as far as arguing about trace. I don't remember that being the case. I remember it being touch and contact, but Judge Hippler has added trace into the mix. So I don't, yeah. So we'll keep reading and I'm sure we will see. So, okay. So separate skill set, right. So the recommendation from this was that the DNA analysts should not opine about the possibility or probability of direct or indirect transfer having occurred in a case. I mean, I think that's fair. Based on these two articles, defendant posits Ms. Nolan as a typical lab analyst and is not qualified to substitute her judgment in the face of the weight of the forensic community's agreement that the science literature does not support any analyst testifying about the when and how of transfer. Yeah. The state responds that the defendant's argument is both legally and factually flawed. The legal flaw is that it misapprehends the appropriate standard to determine admissibility of an expert opinion. The state asserts that the standard is not the consensus of the scientific community, but on whether her knowledge will assist the trier of fact. Factual flaws, the defendant's failure to mention the lack of consensus in the EWG report regarding the recommendation. And then here's this part from the recommendation. Well, the dissenters acknowledge that analysts are often asked to respond to the how and when questions in criminal cases and agree that this testimony on the subject can be misleading or otherwise problematic. They believe that the broad prohibition in the recommendation puts the proverbial cart before the horse by not first requiring an assessment of the type outlined in the recommendation 7.3, footnote 5. So recommendation 7.3 acknowledges the lack of DNA TPPR educational opportunities within the U.S. and recommends that the federal government fund collaborative efforts to review the foundations and principles of evaluating biological results when considering alleged activities, and depending on the findings, make funds available to educate and guide DNA and legal communities on the review, research, selection, and validation of appropriate methods to account for the DNA typing when assessing biological results. I mean, yeah, that sounds like it should be happening. Moreover, they worry that supporting 7.1 would imply the need for analysts to shift to a paradigm that has not yet been sufficiently vetted within the specific context of the U.S. court system. Okay, I think what he's getting at here is that what the state has said is that the defense left some part out, right? And that the part they left out was that part of the recommendation was based on the fact that they're like, well, hey, we should have more funding available to put more to look into this further and do some more research and etc. Like, right, what we just read here, footnote 5, to better make that determination. And that's where it's like the cart before the horse, right? That's what the state is saying, because this recommendation was like, well, let's do more research and then reevaluate type thing. That's what the state's saying. Moreover, they worry that supporting, oh wait, I already read that part. Right. I agree. I do agree with this, that trace doesn't connote the suspect necessarily coming into contact with the object. I agree. Yeah. Touch and contact both have that connotation of like they handled the item, right? So it is a defensive. Yeah, it's the defense's motion. Right. Yeah, it's the defense's motion. Okay, the court finds Ms. Nolan to be sufficiently qualified to render her opinion on DNA transfer, despite her lack of specialization in DNA TPPR. The test for determining whether a witness is qualified. Okay, now we're back to this whole witness being qualified thing. Again, this is not, I'm not going to read all this. A lot of this is just stuff we've seen before. Is she qualified, etc. He's going to say she, I mean, you can see, yeah, of course he's going to say she can. Baltimore. Right. The defendant has not established a scientific consensus in the United States outside of the EWG group, which is comprised of only 25 individuals, only some of which are forensic scientists. Okay, notably absent from either party's briefing are court cases discussing the issue of whether DNA analysts are qualified to testify to DNA transfer. Welcome, official. A review of case law reveals that such opinions are offered by DNA experts without disputes over qualifications, footnote 8. Okay, that's just citing the case law there. It appears that only one court, a military court, has squarely addressed the issue and declined to find the DNA analyst was unqualified to render testimony. In doing so, the court rejected the notion that DNA transference was a separate science from DNA extraction and analysis, and therefore the expert in DNA was qualified to testify to transfer. So yeah, so this doesn't surprise me. I was referencing the Casey Anthony trial earlier, and I almost said it, and then I just didn't say it. But what I was going to say is this, that the state didn't have separate experts for the different facets of DNA, right? Versus like the forensic side in the lab versus understanding the mechanism of how it gets transferred, but the defense did. So I just wanted to follow up on that. And so, so in other words, while it's not required, still, I mean, that trial was in 2011. It's still not required that they have separate experts for DNA. That, and a requirement would be like for the government, right? The one who's bringing forth the charges. But it is something that has already been done again, since, again, that trial was 2011, and that from the defense side, they want to have, at least in that trial, and I would imagine in others, and probably in this trial too, right? Again, so while they can't preclude, at least at this juncture, right, an expert for the government, let's say like a forensic expert, right, for DNA to be able to offer this testimony about touch and transference and whatnot. You still have that option, right? And the state has that option still. Like the state could still bring in someone else for these different facets, but they can't. The case law doesn't support not allowing the expert to testify about it, basically. So that doesn't give the state an incentive to do so, right? In some, there's another footnote. Hold on. All right. While military courts are governed by separate evidentiary rules, the rule governing expert testimony is the same, right? Okay. In some, given the liberal standard for qualifying a witness, and that's exactly that summarizes what I was just saying. The liberal standard for qualifying a witness. That's really what it comes down to, right? Ms. Nolan's experience and training in the area of forensic analysis of DNA generally, the current divide in the forensic community, Defendant's challenges to her qualifications affect simply the weight to be afforded to her testimony. Right. So in other words, the jury could decide. So it's weight, not admissibility. Admissibility, he's saying it's admissible, right? But the weight, that means the jury, as the triers of fact, right? Daryl was told they can, determine witness credibility. And you guys have heard this a million times in cases, and that applies to experts as well. So the jury can determine how much weight to give her testimony, but her testimony will be admissible. Okay. Ms. Nolan's testimony will assist the trier of fact. Right. Again, this is going back to like being an expert, Okay, defendant argues Ms. Nolan's rebuttal opinion that the DNA detected on Q1.1 is, quote, more likely the result of a direct transfer is speculative because it offers possibilities that are not based on substantive scientific principles. James finally got his membership back. Awesome. Love it. Happy, just in time for our members only live stream. The state responds that Ms. Nolan's rebuttal disclosure sufficiently explains the scientific principles underpinning her opinion and the reasons for her opinion. In addition, the fact that Ms. Nolan cannot testify conclusively as to when and how the DNA arrived on the knife sheath does not, according to the state, render her opinion speculative or otherwise unhelpful. The court finds Ms. Nolan has identified an adequate scientific basis for her opinion. Her rebuttal disclosure reveals that she will discuss the difference between single-source DNA profiles and mixtures, concepts pertaining to direct and secondary transfers of DNA, and the variables that can influence the transfer, persistence, and recovery of DNA. And footnote 10. Okay, the variables cited in Ms. Nolan's rebuttal disclosure include whether the DNA profile was single source or mixed, whether the transfer was through body fluid, the depositor's biological factors, so for example, shutter status, personal hygiene, rate of perspiration. And those, of course, are things that we can never know about, like at least not this point, about somebody, like for a criminal defendant, right? The composition of the surface, the length of contact, the nature of contact, environmental conditions. So like as far as all these different factors, the things that can be known for a criminal trial, right, are going to be the composition of the surface. and maybe sometimes the environmental conditions. For example, was the item underwater? And that's it. That's all that they can opine on for the factors to help the jury determine the likelihood of the DNA being deposited there, right? And how it happened and when and whatnot, right? Okay, so that was, what footnote was that? That was footnote 10. Okay. In fact, this discussion closely mirrors the TPPR DNA principles advocated in the article cited by the defendant. Member for a month. Love it, James. Awesome. While defendant may not think Ms. Nolan is adequately qualified to offer an opinion on DNA TPPR, what the fuck is the DNA TPPR? I don't know that that's even been outlined. Does anybody know in the chat? I think it's like the typing, but it seems like it's specific. So the does not. So that should say that does not render her opinion devoid of scientific principles. In addition, although Ms. Nolan admittedly cannot testify conclusively as to whether DNA was transferred to the sheath by direct contact rather than indirect, this does not render her opinion speculative. Welcome, Happy Annie. So they're saying it's not speculative. Her opinion does more than suggest possibilities. She states that while it is possible that the DNA on the knife sheath was from secondary transfer, it is more likely that the result of direct transfer, given that, and we literally already read this part, but what we didn't have earlier was the amount. So it's 0.0168 NGs of DNA. As the state points out, an expert may testify to a likely opinion, particularly where the expert acknowledges the limitation of such opinion. Okay. We don't need to read the case law about somebody being hogtied because that's awful. Ms. Nolan's opinion is no different. She will testify that based on scientific principles regarding DNA transfer and her observations of the quantity of DNA and type of profile found on the knife sheath, it was more likely a direct transfer rather than secondary. Okay. Neither party has cited case law discussing the admissibility of expert opinions on DNA transfer. However, the cases reviewed by the court indicate that Ms. Nolan's opinion is acceptable despite her inability to reach a definitive conclusion. And thank you so much, James, for the super chat. And I appreciate you guys. Y'all don't need to be thanking me. I thank you guys. I thank y'all for always being here. I know there's a ton of people streaming right now too for like myriad cases. So I appreciate this would be so pointless without y'all here, right? That's why we do this, because Scroll Crew's the best, and I love you guys so much. And thanks to y'all, right? But also just thank you so much for your generosity and for your support. It means the world to me. So this is from a different case here. They're referencing this case law. Supporting that it's okay to testify about this for her opinion. All right, misleading. Now, this is really the most interesting thing here, I believe, right? That we were waiting to see what was going to happen. Misleading DNA labels are to be avoided. Okay, this is getting into, is this a good ruling for the defense? You know, we were talking about this a little bit earlier. All right, let's see. Defendant next argues that the term touch or contact DNA should be excluded. I mean, technically, he seems to be he's granting what they ask for, right? It seems like. Should be excluded under the rules. Because it could mislead the jury into inferring that the depositor of DNA actually touched the object. Right. Exactly like what we were saying, Franks. Right. Yeah. Touch the object on which it was found. The state only addresses the term touch DNA and argues it should be allowed because it is a common term within the field. Further, the state points out that it'll be clear to the jury from Ms. Nolan's testimony that touch DNA is a term used only to distinguish the type of DNA from other kinds of DNA, footnote 12. Ms. Nolan's disclosure states she will discuss the characteristics and nature of touch DNA. Okay. Relevant evidence may be excluded. Okay, we know this rule, this 403. There it is. Yep. Okay. The issue here is whether the word touch is prejudicial as it implies that the DNA was transferred via touch. Yep, that's the problem. So now he's saying that like the history in the case law as to how it's been referenced, and I think we are all very well aware of that. Oh, and there's Ruthie Ballard, defense expert there. I thought she was going to be an expert for the state. I guess not. I mean, I remember we deep dove into her whole website and all her children's books and stuff. Okay, however, as one of the defendant's articles observes, the term touch can be misleading, as it implies a specific mode of action and to some degree also a type of biological source. Okay, the term trace DNA implies amount. The word trace is defined as a very small amount and is used in the scientific literature when describing evidence samples with low amounts of DNA that do not yield a profile or only a partial profile. I would not be willing to use that term. Okay, this is from Miss Nolan, right? From her disclosure. So I would not be willing to use that term, and it would be inappropriate to apply that term to DNA on the knife sheath because a trace amount is not what I detected. This is why, okay. All right, now it makes sense to me. So, okay. Again, so just to circle back, remember the defense motion was on touch and contact, not trace. They didn't want to prohibit the words touch and contact. And remember, just a few minutes ago, when I was like, well, it seems like Judge Hippler is one that added trace in, right? And Franks and I were like, trace seems like a really fair way to put it. It seems like Judge Hippler has added trace into the banned words, if you will, for lack of a better description, even though it wasn't asked for, which is interesting. I'm kind of surprised he can even do that, because of what Miss Nolan said. Oh, yeah, this is weird because it implies that it's a small amount, and Miss Nolan was like, it wasn't a small amount, is basically where this is going. Wow. A small trace amount is not what I detected. So I still believe, like what Frank's saying, that trace would be fair, right? The defense didn't ask for that to not come in. Judge Hippler made that decision because of what Miss Nolan says, because he's implying that it was not a small amount. Oh. So I don't like that. I think trace should be allowed. Jesus. This is almost kind of like, look, you want me to keep out touch and contact? Fine. But I'm going to, it's like almost like, in a way, it's almost like punishing that. Okay. Here, I'll give you what you want, but I'm going to punish you for asking for it type thing. What's a better example of this? Like when you've got kids or something and they ask for something they want, they're asking for more ice cream or whatever. And like, because, okay, they're asking for ice cream. So you're like, okay, fine, I'll give you ice cream. And then it's like, no, we want a different type of ice cream. And then it's like, so no ice cream for you. I don't know. I'm trying to think of a better example. Maybe you guys will think of something in the chat, but like, you guys see what I'm saying? It's like punish. I don't know. Interesting. But it's also weird that he can just make this decision. Like this wasn't asked for. Like neither the state nor the defense asked for the term trace to be kept out. Franks, what are you referencing here? Is this about trace, like a definition here? The amount of DNA present, the quality of DNA present, or to DNA detected by an LT-DNA technique. The misleading nature of both these terms is a real danger. I'm not sure. I think. Oh, so she says, I'm reading an article which also doesn't agree with trace. Okay, I see. So the thing that I'm first highlighting here is the first issue here is like, okay, it's really not even about whether trace, okay, is a good term to use or not a good term to use. What I'm really surprised about is that he's making a ruling on it when neither side asked for it. That's the thing. That is really the thing, right? Like, because I just don't think I've seen that, right? Like neither side asked for it. So that to me is the bigger, like that's the first and foremost issue, right? Because if he's just making a decision, I don't know, that's the legality of it, right? Of just making that decision when neither side made a motion. To where now even the discussion about the term is like almost moot. Kind of crazy. let's see what else he says here. Given the ubiquitous of the term touch DNA in not only the forensic DNA field, but also in the legal and scientific field as well, the court is unwilling to prohibit the term. There is too great a risk that a witness or counsel will inadvertently refer to the term out of habit. Wait. I thought he said he wasn't going to let them say it, but now it sounds okay. Let me just keep reading. Potentially giving rise to a motion for mistrial for violation of a court order. Moreover, the court is not concerned that the jury will be misled, that both parties have DNA experts who can easily disabuse the jury of any mistaken correlating touch DNA with actual touching. That said, the court asks counsel to avoid the use of the terms as much as possible. Oh, okay. So it sounded a lot better in the beginning than it really is. He's just like, avoid it. Oh, this is a weird order. Footnote 14. This limitation includes the terms touch DNA and contact DNA as was requested in the motion. In addition, here it is, guys. Based on Ms. Nolan's concern over the term trace DNA, the court will advise against its use as well. I've never seen this before. Because of the expert in that one paragraph having a concern about trace, neither side moved for this. That's crazy. See, I just don't even, what? Now, having said that, it's just like avoid the use of the term. So it's really not like they can't say the word. So, but still. Oh, okay. So as much avoid the use of the terms as much as possible so that any potential confusion can be bypassed. To this end, the parties are instructed to submit a mutually agreeable instruction to provide to the jury in case the terms are inadvertently used. So Frank's is saying I'm seeing this as a common complaint in trials. Which one? These use of these terms? Is that what you're saying, Frank's? To this end, the parties are instructed. Okay, I already read that part. If a witness uses the term, the opposing counsel can examine the witness about a broader meaning of the term. Okay, her opinions are proper. Right. I mean, this doesn't surprise me that really the terminology was the most interesting here. Okay, so order based on the following, the defendant's motion granted in part and denied in part. I disagree. It's really denied in its entirety, but under the guise of looking like it's granted in part, because he's saying try not to use these words, but he's also added another word into the mix. And this is a very, very, very weird filing right here. Yeah, I mean, it really, honestly, it comes up with every single trial, right? With every single trial, because DNA evidence is so huge. And in every trial, it comes up about the source and not the source, sorry, just the languaging, right? How you're going to label it. I mean, it's in every case. It's in every case. And then there's also the whole other thing of like when things are inconclusive. And what does that mean? I mean, there's a lot of legality surrounding this, as we know. That's without even getting into IDG. But just as far as the DNA is concerned. So this is very weird filing. I think it's granted in part and denied in part. Wow. I'm gonna have to digest this because this feels very weird to me from the judge. All right, next up, psychiatric evidence. Okay. So the state seeks to prohibit the defendant. So this is the state's motion, right? The defendant from offering any testimony during the penalty phase in connection with his neuropsychological and psychiatric evaluations performed by his disclosed experts. Yeah, it's so crazy because like at first it seems like they were like saying they weren't going to try to keep this out as long as it was in the penalty phase, and then they filed. I'm just trying to remember the order of this because there were so many motions. It just blows my mind that they're making this motion. Okay, the state argues that the proposed testimony falls outside the mental condition evidence allowed by the Idaho Code. Okay, now I'm remembering. Now it's coming back to me. They were like saying that the bar is like you have to have like a really low IQ and stuff. Okay, defendant responds that he is not relying on the proposed testimony as a mental element defense under the code. noting his relevant diagnoses are physical conditions, not mental conditions. Rather, he intends to present the evidence to aid the jury in understanding both the physical implications of his diagnoses and contextualizing his allegedly unconventional courtroom demeanor. Oral argument was held and the court took under advisement. So, okay, this is why I was thrown off, because my recollection was like, this was for the guilt phase, right? But this says penalty phase. I am wondering if this was a typo. I'm wondering if this was a typo, because this was supposed to be what is happening? Hold on, let me look back at the docket. There's been, and the reason I'm saying that, there's been a ton of typos in these orders from the judge this time around, so it wouldn't surprise me. So this looks like this might be the most recent filing from the state regarding the neuropsychological and psychiatric evidence. Why is it like that? Don't do that. Yeah. Again, guilt phase. They want to explain how he appears before the jury. Remember, we talked about this, the voir dire and all that. We talked about this. This is guilt phase. How he's going to be perceived by the jury. And we know there's no mental health defense. All of this is guilt phase. Wow. They talk about his upbringing and all this. Okay, so here's what they're asking for, right? The state. Okay. Prohibiting the defendant from offering evidence of purported explanations of how he may appear in front of the jury, reversing ruling on whether the defendant is entitled to offer rebuttal evidence of his mental condition to the extent that it might offer an alternative explanation to any of the state's evidence about defendant's suspicious, unusual, or otherwise odd behaviors, deny the defendant's introduction of newly disclosed evidence regarding the physical condition. And it even says here, right here, there it is, state's guilt phase. It's rebuttal to the state's guilt phase expert disclosure. Okay, so that's settled. That's settled. This is a mistake. It's not penalty phase, it's guilt phase. I will just say that is a big mistake to make. That is a huge mistake to make. That's different than a typo. That is crazy, because that completely changes the context of this. And that's why my brain was like, wait, what? I was buffering. I was like, wait, what? Oh my God, that is a mistake. Okay, I'm looking at what Franks is saying in the chat here. So it looks like somebody tested the hypothesis that secondary transfer of a third person's DNA to a knife handle can happen by mere handshaking with the person who would later actually handle the knife. They used controlled and cleaned knives of smooth and textured blades and ensure that the secondary hands were controlled and cleaned as well. The handshaking occurred for 2 minutes to replicate other forms of intimate contact. Following the contact, the primary participant immediately handled the knife. The results were staggering. Secondary transfer occurred on 17 of the 20 knives. In 5 samples, complete foreign alleles were discovered. Wow. This should be the defense. Most concerning is that in 5 of the 20 knives, the secondary contributor was either the only DNA contributor or the major contributor, despite never having come in contact with the knives, into direct contact with the knives. Franks, well done, man. Dude, yes. This is, thank you. Well done. That's huge, right? I'm going to read this again. Wow. Okay. Let me read this again. So they tested the hypothesis that secondary transfer of a third person's DNA to a knife handle can happen by mere handshaking, right? So you shake your hands with 2 people are shaking hands, right? And then one of the 2 goes on to handle a knife, right? So they had everything controlled. They had they cleaned the knives. The handshaking occurred for 2 minutes. And then following contact, the primary participant handled the knife, the one who's supposed to be, as if the person who actually committed a crime, right, in this experiment, to show what would happen. And then, secondary transfer occurred on 17 of the 20. And in fact, wow. But this is the crazy one here. Like, the most concerning is that in 5 of the 20 knives, a secondary contributor was either the only DNA contributor or the major contributor. And it's the person who never actually touched the knives. Wow. Thank you for that, Franks. Well done. Thank you. Thank you. Okay, so now that we've clarified that Judge Hippler needs to read these, like, that is a huge mistake. This is the guilt phase. Okay, not the penalty phase. Jesus Christ. So then we have a footnote. Okay, whatever. Expert disclosures. Okay, the state argues the proposed testimony falls outside the mental condition evidence. Right. And again, all this, again, was what led me back to, like, hang on, I think this is a mistake. This has got to be the guilt phase. So rather, he intends to present the evidence to aid the jury. Right. Okay. They heard oral argument. Okay. Standard. The question is whether the evidence is relevant one of law, while the decision to admit relevant evidence is discretionary. On discretionary matters, okay, again, literally, this is in every one of these filings. I'm not going to read it again. During the course of this case, the defense team retained Dr. Orr, a clinical neuropsychologist, to complete a comprehensive neuropsychological evaluation of the defendant and issue a report. She ultimately diagnosed the defendant with ASD level 1 and other things here. So we have OCD and then the developmental coordination disorder. According to Dr. Orr, ASD is a complex. A lot of this is we've already read, right? We read all this stuff in its entirety with the other. He's just citing it, so we don't need to read it again. There's a wide range of symptoms, we know. Again, citing the things like the intense eye contact, all of this, we already know. The types of conversation, the OCD manifested through compulsive cleaning behaviors. Again, this was all in the other filings. Although defendant does not carry a current diagnosis of DCD, Dr. Orr opines that he met the criteria for the diagnosis in the past. This is the one where I was like, there's no way this is going to be coming in my opinion. The only observation Dr. Orr made with regard to the defendant's fine motor dexterity was the defendant moved his arm. Okay, right. He moved his arm when it was repositioned, that whole thing. Just Beth is asking a good question. I don't remember what the deal was with the defense testing it. I don't recall reading in any of the filings or hearing in the hearings anything about them not having enough to test. So if someone can remind me where that came up, I don't remember that even being the case. I guess I assumed that they were able to test it. I assumed that they were able to test it. Were they not able to test it? I don't know where did that come from? And I'll be honest, I'm not the person to assess whether the DNA amount is huge or not. I mean, that's what the experts are going to have a battle of the experts over that exact thing, right? It was only Riley Nolan who said that because of the amount, she wouldn't call it trace, because in her opinion, it doesn't count as trace. But again, they're going to fight over it. And I have I'm not the one to be able to say. Franks might be able to say, where it had where is it? It was in a different filing. Hold on. The NGs, I can't even remember what that stands for. Again, that's my level. I'm not but Franks might be the person to weigh in on, I've seen people say it's not a lot. I don't know. I imagine that depending on people's opinions, they might interpret it differently, right? And, I feel like the best way to assess it is really from a more objective approach. But having said that, when it comes to trials, it's always going to be a battle of the experts. And so I don't know that anybody can even look at this stuff and be objective when it comes to the DNA in terms of like assessing the quantity, right? I mean, it's just literally people that don't know are going to assess it based on what they think what they think happened, right? And then the people who know, which are the experts, are going to battle over it in court, and they're both going to say opposing things to each other. So, but where was it? Let me do this. Oh my God. I didn't think that would. Hang on. I think it might be on this page. Maybe not. There it is. Found it. 0.0168 NGs of DNA. I'm not the. I will just say this is not in my wheelhouse. I cannot opine onto that at all. Oh, nanograms. Thanks, Franks. Yeah, I should have figured that. Yeah. Correct. As far as what, yeah. So if not Kohberger, somebody in close contact with Kohberger. Correct. That's correct. AZ. Yep. For AZ is referencing here the study that Franks was talking about. That was really interesting. Maybe someone in contact with BKR, maybe as far as the foreign alleles. Frank says, if I were on the defense, I would go with foreign alleles. We don't know how they got on the sheath until we find the real killer. Right. Okay. No mention of fingerprints in the study. Right. And the thing is you can have trace DNA, right? That isn't touch. Correct me if I'm wrong. I mean, my understanding, like, for example, you could have like the teensy amount of like DNA from like blood, for example, right? I mean, in my mind, I would consider that probably counting as trace. It depends on the amount, right? So trace doesn't have to be touch or contact, right? I mean, that's my understanding. Again, not my expertise when it comes, but, and it again, it's just, and people will, clearly there's a lot of controversy about how to use the words, and people, the experts, there's just, but that's my connotation, right? It would be like trace doesn't have to be touch or contact. But that, yes, typically touch and contact would probably also be trace amount. So in other words, like a fair amount, or maybe a majority potentially, of touch or contact DNA would be trace, but not all trace DNA is necessarily touch or contact. That's kind of maybe how I would interpret it. Okay, but now so we're back over here to the autism. Okay, let's see. So, it's so funny. I pointed this out. The Dr. Lewine, I was like, wait, why is he writing in a thing? He was not disclosed by the defendant as a retained expert. So I thought, I pointed that out before. I was like, he submitted a declaration, and I was like, wait, what? Anyway, I don't know what the deal's with that. Okay. Right. Mens rea. Yeah. So in other words, it's like everybody's in agreement, right? They're not using this evidence to try to be like, he didn't have mens rea. Everybody's in agreement. So I'm not even gonna read all this because like, it's just not part of the conversation here. Evident of defendant's diagnoses. Having determined that other code does not apply, next question is whether evidence of defendant's diagnosis is relevant. We know what relevant evidence is. We don't need to read that again. Again, this is all very much repetitive. Rule 403. Evidence of ASD to explain demeanor is only admissible if the defendant testifies. With regard to his evidence of ASD, the defendant contends it is relevant to explain that his ASD diagnosis is a physical condition and how it presents in his demeanor. Specifically, the defendant asserts testimony about his ASD will help the jury understand that his behavioral characteristics, such as flat affect, intense eye contact, awkward body posture, and lack of emotive responses are associated with ASD and should not be interpreted in a sinister light. Yep. State responds that the defendant's demeanor is not a fact of consequence in this case, and the jury is not even evidence the jury can consider, at least if he does not testify. And then there's the case law. Again, this was in the filings. While the relevance of the defendant's demeanor is raised in a different context here, the principles of this body of law apply equally. The Supreme Court has declared that one accused of a crime is entitled to have his guilt or innocence determined solely on the basis of the evidence introduced at trial and not on grounds not adduced as proof at trial. I mean, this is why it's annoying, right? Because we all know they're going to sit there and judge his demeanor, even though it's not evidence. They're going to do it, right? I mean, I just don't think an instruction is going to help with that. A non-testifying party's demeanor is not included and therefore legally irrelevant to the question of guilt. But we know that with every jury, whenever they come and speak out, they look at the defendant and just y'all know. While defendant cites the case law allowing evidence of ASD in the criminal context, those cases are distinguishable. So he's saying they don't apply, and that the oddities in the behavior were not discussed in the opinion. Okay, the other case law saying how it doesn't apply. Again, these are not this case; these are other cases. Okay, not one of the defense experts has ever imputed behavior to him that remotely approaches the odd behavior in Burr. He's going to probably deny this. Let's see here. Consequently, testimony about defendant's ASD is simply not relevant if he does not testify, footnote 9. So I wonder if he's going to say it's relevant if he does testify. Let's just see. Moreover, introducing such evidence risks confusing the issues. Again, that's Rule 403. While the court is not blind to the fact that the jury will be scrutinizing the defendant's courtroom behavior during trial, allowing testimony about his ASD to explain his courtroom behavior amounts to judicial endorsement of improper evidence. It essentially invites the jury to consider the character of the accused to determine guilt, which is not proper. So what he's saying here is if he's going to be giving them an instruction that they can only consider evidence that comes from the witness stand, right? And then turn around and say, you can't, like, here's this explanation for the defendant's behaviors as he sits there not taking the stand, for example, right? That it would almost draw more, it would defeat the purpose and draw more attention to it. That's what Judge Hippler is saying. See, look, it'll focus the juries even more on the defendant's behaviors that they likely would not have noticed in the first place. And I disagree with this. It may also diminish the weight assigned to the evidence when the jury is instructed to consider in aiding its determination of guilt. Essentially invites the jury to consider the character of the accused. What he's saying is it would do more harm than good. What do you guys think about that? It would do more harm. That's what he's saying. It would do more harm than good. That's literally what he's saying. It additionally risks playing into the jury's sympathies to the prejudice of the state. State has no rights in a trial, by the way. Moreover, expert testimony, particularly on a diagnosis as encompassing as ASD, will consume a significant amount of time in an already lengthy trial. I don't like this ruling at all. Consequently, if defendant does not testify, evidence of his, okay, here's the thing. It is not up to Judge Hippler to decide. It's for Bryan Kohberger's defense team to decide. And it's a strategy, right? They want it in. Great example. Okay, take Karen Reed from the other day. Remember when Bryan was like, well, I think that it's bad for the defense to have the car there at the jury view, right? And she was like, but they want it there. And he's like, but I don't think that helps them. I think that's bad, or whatever it was. He was like, it's going to be too prejudicial. She's like, they want it there. They requested it. It's going to, right? You see what I mean? Like, similar thing where it's like the defense for a reason, right, decided that it would be more helpful for the jury to have an explanation of his behaviors. So for the judge to then come back and say, well, no, it would just draw more attention to it. So it's just going to do more harm than good. That's the first thing. And then the other thing is saying that concern about prejudice to the state. And then the third thing is taking too much time. So basically, what you've got is him saying, I mean, what my point is this. All three of those things, to me, trample the defendant's rights in a death penalty case. His defense team wants this to come in. So for him to then make the decision, no, you don't know best. I know best. This was just draw more attention to it. This is not what you want to do. That's not his job, right? And then to be concerned about the prejudice of the state and then taking too much time in an already lengthy trial, you've got to be kidding. That the fact that he mentions that is crazy. That he's concerned about it taking more time to add that in. You've got to be kidding me. Oh my God. Wow. That blows my mind. It blows my mind. That is not that. If he wants to think that, which he shouldn't think that, fine, that's one thing. But to put it in the filing is crazy as a basis for his ruling, whatever it's going to be, is crazy. Okay. If, however, the defendant testifies, evidence to explain his demeanor may become relevant. At that point, defendant's demeanor, which goes to his credibility, is relevant evidence to a jury can consider, which the state concedes. However, prior to presenting testimony on the matter, defendant must raise the matter with the court outside the presence of the jury to discuss the permissible scope. So then this court reserves ruling on the admissibility of OCD evidence. Okay, he argues that if the state elicits testimony at trial related to these facts in order to support the elements of the crimes, evidence of these manifestations will be proper rebuttal. So, for example, if they're like, oh, he's washing his hands because he killed people, and then it's like, nah, he has OCD, right? The state responds that it does not intend to introduce any evidence during the guilt phase as to the defense's odd behaviors, social miscues, or other unusual behaviors. However, it requests that the court reserve ruling until the time of trial. So things that were examples given from the defense, I think they talked about him having a lot of showers and like using gloves and stuff like that. And you can see where that might come in from the state, right? Evidence of OCD is not admissible to rebut ability to commit crime. Obviously, no one's saying that it is. Okay, let's read these footnotes. A defendant's ASD can certainly be raised in voir dire, including questioning the jury panel about whether they can avoid judging the defendant improperly based on how he presents at counsel table, which may allay the defendant's concerns about how the jury will perceive him. Yeah. Dr. Orr noted in her report that the defendant engages in self-soothing activities to decrease sensory output caused by ASD, to include spending extensive time in the dark and driving. This is not linked to his OCD, however, which is why he's like, I'm going to reserve ruling on the OCD, but the ASD is not coming in. That's my opinion on Judge Hippler with that. Footnote 12, by way of example, he notes that just prior to his arrest, law enforcement saw him wearing gloves and handling baggies. Ah, yes, the gloves. Believing he was destroying evidence, law enforcement abbreviated its knock and announced procedure. If the state introduces this or similar evidence at trial, defendant asserts that evidence of his own. So, okay. Here's how I see this going. Fuck. Okay, here's how I see this going. If they've got whatever law enforcement officer it is, this by they, I mean the state, and on direct, and they ask about the knock and announce procedure, and they talk about it, and they're like, did you follow that here? And they're like, no. And then it's like, well, why did you not follow it? And they're like, oh, he was wearing gloves, and so we were concerned he was destroying evidence. Then that opens the door for the defense to then bring in the OCD evidence, right, to rebut that behavior, the explanation of that behavior. However, if they have one of these same officers, again, the state, right, on direct, and they're like, okay, like they're talking about the arrest, and they do not talk about the knock and announce procedure, and they do not talk about the fact that it wasn't followed because they believe he was destroying evidence because of the gloves and the handling of the baggies, whatever, then I think that would be very different, because then it would be up to the defense to ask the question about them not following their procedure in order to get to, it's interesting, right? Because it's almost like which side it's almost one of those things, right? Kind of like with Cousin Eddie and Murdoch. Like, okay, if you're the state, you probably are gonna be like, well, fuck. I want to get in this bit about him destroying evidence. However, I don't want to open the door to the OCD shit. And like if we get into the destroying of the evidence, then it could open the door, right? And also they probably don't want to get into law enforcement abbreviating the not going to announce unless they can really hit the point home that he was destroying evidence. If you're the defense, you probably also don't want to get into it, right? Because while you want to be able to get into the OCD, it would be even better if it just doesn't, it'd be even better for the defense, right? If the destroying of evidence bit doesn't come in at all. Like, so for that reason, if you're the defense, you could also consider not asking them. Well, let's just say on direct, the state doesn't get into the not going to announce bit. And it's like leaving it up to the defense, right? The defense wanting to get into the OCD, well, then the risk they're taking is then in order to get to that part, you have to first get to the part about the destroying of evidence. So this is interesting. Wow. There's a lot of strategy there on how this will be handled at trial. Because it could be that neither side therefore asks about this at all because it's too risky, right? The opening of the door. Okay. Where was I? Right. Again, if the state elicits the testimony at trial, like I said, that's why I said it matters for how it comes out. If the state elicits the testimony at trial related to the facts to support the elements of the crimes, then it's proper rebuttal. The state elicits it. If the defense elicits it, that's where I was going with that. If the defense elicits it, then it's not, right? That's how it works. That's how opening the door works. The other side has to do it. So in other words, they can't elicit it to then bring it in on rebuttal. But where I was going with that is like, that probably wouldn't be a good idea anyway, because in order to get to that, you first have to get to the destroying evidence thing. But again, that wouldn't be how it works. The state would have to open the door. That's what it is. Welcome, Leslie and Billy. Okay, the state responds it does not intend to introduce any evidence during the guilt phase as to the odd behaviors, right? Evidence of DCD is not admissible, right? And this is not coming in. I guarantee you the DCD. And this Dr. Lewine's not even an expert. Okay, I'm going to go ahead here. Define motor dexterity. It's not going to come in. So based on the foregoing, the state's motion in limine is granted in part and reserved in part. And the reserved in part is as it pertains to the OCD, and it would be only if the state opens the door. And it was the state's motion, right? So granted means the ASD can't come in. So here's the summary of this one. The ASD can't come in during the guilt phase. The DCD or whatever, DCD can't come in during the guilt phase. The OCD can only come in the guilt phase if the state opens the door. That's the summary. That's the long story short of this. That's it, guys. We are overdue. We're past. I never know how long these are going to take, right? But we got to switch over to our members only live stream for trivia night. It's going to be super fun. I'm super excited. So a lot to digest here still, though, with the tone of these from Judge Hippler. And, interesting conversations with the DNA. Thanks so much for all of you guys who were sharing your knowledge in the chat. Love it. But that'll be it for this particular live stream. And like I said, we are going to redirect. It should automatically redirect you guys, I believe, into the members only live. So I'll see you guys in just a second. But until then, scroll out.